Hello, doctors. I'm Dr. Chris Rapoff of EZ QME, Continuing Education, and welcome to this week's Case Law Update. Today's case is a pretty interesting one, and here in the Martinez versus the Marion Regional Medical Center, we have a situation where a clerical inadvertence could potentially cost the defendant pretty dearly. So, did an error by the insurance carrier affect the outcome of a workers' compensation case? Hard to believe, but let's take a look. So here we have a case in the Martinez versus Marion Regional Medical Center, where Ms. Martinez was employed as a cook for Dignity Health, which was a subsidiary of Marion, and she claims that she suffered a specific injury in April of 2018 and a CT injury from 2008 to 2018 to her cervical spine, right shoulder, and left shoulder. Now, the defendant admitted to the right shoulder and cervical spine injury. They denied injury to the left shoulder, stating that the left shoulder injury did not rise out of and in the course of her employment, AOE, COE. Now, an orthopedic AME was selected to evaluate Ms. Martinez, and he diagnosed her as having a status post right shoulder arthroscopy with subacromial decompression, a distal clavicle resection, and a rotator cuff repair in 2018. He also identified a cervical spine strain and wanted to rule out cervical radiculopathy, and also left shoulder impingement syndrome, deferring the final diagnoses to some diagnostic testing. Now, after the receipt of the diagnostic testing, the AME provided a report and stated that Ms. Martinez suffered an injury to her neck and right shoulder, but she did not suffer an injury to her left shoulder. This is the point of contention. Now, in the AME's report, specifically addressing the left shoulder, he stated that first the onset of her left shoulder complaints in the medical record appears to be in March of 2019. This was almost 1 year after the industrial injury that she reported. Now, following the industrial injury, she stopped working in June of 2018. So she had the medical records appearing in March of 2019. She stopped working in June of 2018. So he stated that she wasn't putting any physical increased demands on her left shoulder during the routine activities of daily living while unemployed. And he also mentioned that there was insufficient medical evidence to indicate that the left shoulder was even injured as a result of the industrial exposure. Some more facts in the case. In June of 2020, the AME did conclude that Ms. Martinez did suffer impairment to her cervical spine and right shoulder, and he opined that 15% of the non-industrial apportionment was due to degenerative underlying processes of the neck and right shoulder. In September of 2020, Ms. Martinez underwent a left shoulder subacromial decompression surgery, which the defendant had authorized through, believe this or not, clerical inadvertence, also known as a slip-up or an error. Now, in April of 2021, the AME issued another supplemental report, and he reaffirmed his position that Ms. Martinez's left shoulder was non-industrial, and further determined that she had not suffered any CT injury with the defendant regarding the left shoulder. So the case moved on to court, and in 2023, they proceeded to trial, and the workers' compensation judge issued a findings and award that Ms. Martinez had suffered and sustained an injury to her cervical spine, right shoulder, and at this, left shoulder. Also, this ruling included an apportionment due to a pre-existing degenerative changes. Now, with respect to the left shoulder, the judge explained, and they say, quote, while the AME ultimately concluded the left shoulder was not injured on the industrial basis, due to the fact that the carrier authorized and provided left surgery in September of 2020, which resulted in permanent disability, this results in the left shoulder to be found to have been injured on an industrial basis. And this is what we will discuss further. This is where the situation gets a little contentious. Now, the defendant contends that because the AME identified the whole person impairment arising out of the applicant's left shoulder surgery, that the workers' compensation judge interpreted this as the AME's endorsement of an industrial causation. It's not the case. The petition further claimed that the apportionment was described by the AME constitutes substantial evidence. Now, the applicant contended that because the carrier authorized and provided the left shoulder surgery on an industrial basis, even though it was erroneous, any permanent disability resulting from the surgery would be industrial. And this is where the question comes in, is this the case? So during the trial, the defendant did admit to injury to the cervical spine and right shoulder, but they challenged the judge's determination that Ms. Martinez has sustained an injury to the left shoulder as a result of this mistakenly authorized surgery. But the workers' compensation judge's report makes clear that the determination of industrial causation with respect to the left shoulder was based on the defendant's authorization and provision of left shoulder surgery. So they authorized it, therefore it was an injury. The report actually stated that, quote, once the defendant authorized the surgery and the applicant underwent surgery to the left shoulder became an industrial related part of the body entitled to full benefits. Let's try to understand the legal implications and ramifications of this. We go to Labor Code Section 3600, and actually Part A provides that the liability for a compensation provided by this division, quote, shall, without regard to negligence, exist against an employer for any injury sustained by his or her employees arising out of and during the course of employment. This also says, generally, the phrase in the course of employment refers to the time and place of the injury. However, the phrase arising out of the employment refers to the origin or the cause of the injury. So they then cite other court cases that affirm their conclusion regarding AOE COE. So in their ruling, they did state that the injury sustained as a result of an authorized industrial medical treatment is itself industrial. Because why? Well, it rises out of the original workplace injury. Now, they state a Supreme Court case, and they said that they have observed that it has become settled, as already indicated, that an employee is entitled to compensation for a new or an aggravated injury which results from the medical or surgical treatment of an industrial injury, whether the doctor was furnished or by the employer, his insurance carrier, or was selected by the employee. So accordingly, where they authorize medical treatment will be resulting in an additional injury and disability. So the employer is liable for any compensable consequence arising therefrom. You can imagine this didn't sit well with the AME or the defense. So the AME in his deposition turned his attention to whether or not the applicant, Ms. Martinez, had really sustained an injury or disability as a result of the surgery. So accordingly, the record must be developed to address an issue of whether the applicant sustained an injury as a result of the mistaken surgery. The appeals board also stated that if it is determined that the applicant, Ms. Martinez, had suffered the injury as a result of the surgery, that the defendant is liable for any resulting disability or need for medical treatment arising after. Now, this is taken from the South Coast Framing versus Workers' Compensation Appeals Board in 2015. They also concluded, the appeals board, that the medical reporting in the evidence that was provided did not adequately address the issue of whether Ms. Martinez had even sustained an industrial injury to the bilateral shoulders as a result of the CT injury. So they included Ms. Martinez's job duties. And as you can see, those prolonged standing and walking, raising the above shoulder level and lifting, reaching, repetitive arm movements, hand movements, and lifting and carrying up to 65 to 70 pounds. So it was a pretty substantial job duties that she had. So the AME responds in another supplemental report trying to base his conclusions on substantial evidence. And he says that according to a cover letter in January of 2021, Ms. Martinez had suffered a CT claim from 2008 to 2018 involving the shoulder. However, he states that there was no evidence that she was having problems with the right shoulder prior to the specific injury that she stated in April 2018, and there were no left shoulder complaints documented until about 9 months after she last worked for the subject employer with the health company. Hence, his conclusion were there's simply no evidence that she sustained a CT injury to her shoulders from April of 2008 to April of 2018. Now, the appeals board stated, and they came back with telling us that it's pretty unclear whether the AME actually fully considered Ms. Martinez's work history as it was described in his original report in 2021. And to be considered substantial evidence, they state a medical opinion must be predicated on reasonable medical probability. No surprise. So, in their conclusions, the appeals board stated that in order for a medical legal opinion, as expressed by this AME, to constitute substantial medical evidence, this evidence must be based on a complete medical history and directly address the facts that are germane to the issue of causation, including whether or not Ms. Martinez's work history and job duties were causative of her bilateral shoulder injuries. We discussed those job duties are pretty substantial. Now, the lack of contemporaneous shoulder complaints, they state, is not in and of itself a dispositive of the issue. So they returned the matter to the trial level for the development of the record. And the appeals judge talked and said that the workers' compensation judge may wish to consider instructing the parties to return to the AME for a supplemental report to address one, whether the applicant, Ms. Martinez's work activities during the reporting and the claimed CT injury period may have contributed to the claimed injuries. Remember, to a significant degree for a CT injury is only a 1% threshold. And number two, whether the applicant had sustained injury and or a disability that was arising out of the mistakenly authorized left shoulder surgery. Now, since they returned the matter for further development of the record, they didn't even consider the determination of apportionment that they had already made a 15% apportionment due to other factors. So it's no surprise that the Workers' Compensation Appeals Board actually rescinded the joint findings and award, and they returned the matter to the workers' compensation judge so they could conduct further proceedings that would be consistent with the opinion that they provided here, and to issue a new decision from which any aggrieved person may timely seek reconsideration again. So here we have the defendant who's guilty of clerical inadvertence and a pretty costly mistake by providing and approving a surgery for a worker's shoulder condition that was determined to be non-industrial by the AME. So we have a few takeaways in this case that I'd like to bring to your attention. Now, first, number one, an injury that is sustained as a result of an authorized industrial medical treatment is itself industrial because it arises out of the original workplace injury. Number two, an employee is entitled to compensation for a new or an aggravated injury that results from the medical or surgical treatment of an industrial injury, whether the doctor was furnished by the employer, his insurance carrier, or was selected by the employee themselves. And finally, where an authorized medical treatment results in additional injury and disability, the employer is liable for any compensable consequence arising from that surgery or medical treatment. Wow, what a costly mistake on the defendant's part. Just goes to prove that you have to cross your T's and dot your I's and everything when you're working in the medical legal realm, especially as a QME. So once again, doctors, I'm Dr. Chris Rapoff, and I wanted to thank you again for taking the time to join me in this presentation. I hope you enjoyed this one as well, and I look forward to sharing other interesting cases with you again soon. Until next time, take care.